So I'm gonna get, okay, we're live now. And, oh, lost my page. Here's rule 1.1 competence. Once you're done reading it, remember to press next. You can touch the screen to press next.
Okay. Client-lawyer relationship. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Next rule.
Yep. You can touch the screen to get there.
Yeah, it's going. Rule 1.2, scope of representation and allocation of authority between client and lawyer. The client-lawyer relationship. A, subject to paragraphs C and D, a lawyer shall abide by a client's decisions concerning the objectives of representation and, as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, and whether the client will testify. B, a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. C, a lawyer may limit the scope of the representation if the limitation is reasonable under some circumstances and the client gives informed consent. And D, a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. Next.
Read the title.
Rule 1.3, diligence. Client-lawyer relationship. It's only one sentence. A lawyer shall act with reasonable diligence and promptness in representing a client. So that's diligence. Now, the next one is next rule. Rule 1.4, which was referred to in the first one, communications, client-lawyer relationship. A lawyer shall, 1, promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0 E, is required by these rules. 2, reasonably consult with the client about the means by which the client's objectives are to be accomplished. 3, keep the client reasonably informed about the status of the matter. 4, promptly comply with reasonable requests for information. Wow, my lawyer's doing pretty good according to this. And 5, consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance that's not permitted by the rules of professional conduct or other law. And B, those are 1 through 5 of A. And then finally B, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Let's go on to the next rule. Rule 1.5, fees, client-lawyer relationship. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following. There's 8 of them. 1, the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. 2, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. 3, the fee customarily charged in the locality for similar legal services. 4, the amount involved and the results obtained. 5, the time limitations imposed by the client or by the circumstances. 6, the nature and the length of the professional relationship with the client. 7, the experience, reputation, and ability of the lawyer or lawyers performing the services. And finally, 8, whether the fee is fixed or contingent. B, those are 1 through 8 of A. B, the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any charges in the basis or rate of the fee or expenses shall be communicated to the client. C, a fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D or other law. How the hell do you fucking do this shit? A contingent fee agreement shall be in a writing signed by the client and shall state the method by which the fee is to be determined, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal, litigation and other expenses to be deducted from the recovery, and whether such expenses are to be deducted before or after the contingent fee is calculated. The agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. Upon conclusion of a contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome of the matter, and if there is a recovery, showing the remittance to the client and the method of its determination. Okay, I see this because I have a lawyer. That was C, and this is the rule. Let me go back. This is rule 1.5. This is about fees.
You're halfway there.
Yeah. Okay. Yeah, spoken. Okay. Let me find where I was. C, a fee may be contingent on the outcome of the matter for which the service is rendered, except in the matter. Did I read this? Oh, I did read.
See?
Okay. Okay, here we go. D has two sub things. D, a lawyer shall not enter into an arrangement for charge or collect 1, any fee in a domestic relations matter, the payment or amount of which is contingent upon the securing of a divorce or upon the amount of alimony or support or property settlement in lieu thereof, or 2, a contingent fee for representing a defendant in a criminal case. Is my case criminal? Okay. And then E. That was D1 and 2. E. A division of a fee between lawyers who are not in the same firm may be made only if 1. There's 3. The division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. 2. This is a division of fees between lawyers that aren't in the same firm. If the client agrees to the arrangement, including the share each lawyer will receive, and the agreement is confirmed in writing, and finally, 3, the total fee is reasonable. Next rule. So that was all about fees. This is 1.6. This is about confidentiality of information. Client-lawyer relationship. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. And then I guess it's B here. B. A lawyer may reveal information relating to the representation of a client to the extent that the lawyer reasonably believes these things are necessary. 1, to prevent reasonably certain death, obviously, or substantial bodily harm. 2, this is the same for therapists and stuff. To prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests of property of another, and in furtherance, shame we even need these laws, of which the client has used or is using the lawyer's services. 3, to prevent, you know what mitigate means, right? To lessen or rectify substantial injury to the financial interests or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. Oh, I get it. 4, remember, this is about confidentiality. To secure legal advice about the lawyer's compliance with these rules. 5, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. To establish a defense to a criminal charge, bless you, or civil claim. I don't even know what a civil claim is. It doesn't matter. Against the lawyer based upon conduct in which the client respond to allegations in any proceeding concerning the lawyer's representation of the client. There's 6 and 7, and then C. 6, to comply with other law or a court order. Or finally, 7, to detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. And finally, C, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Next rule. Okay, so that was about confidentiality. Rule 1.7. Ready? Conflict of interest. Current clients. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or, oh yeah, I get it, there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, or former client, or a third person, or by a personal interest of the lawyer. Fuck. B. Notwithstanding the existence of concurrent conflict of interest under paragraph A, a lawyer may represent a client if 1, there's 4, and then we're done to this one. So the lawyer may represent a client if 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 2, the representation is not prohibited by law. 3, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or proceeding before a tribunal, whatever the hell that is. And finally, 4, tribunal. 4, each of, don't explain it. I don't need to know. I don't understand a word of any of this. 4, each affected client gives informed consent, confirmed in writing. Breathe. Next rule. Rule 1.8. Current clients. Specific rules. Okay. Client-lawyer relationship. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless the transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. I've never read anything from a law yet that I understood ever in my life. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. And 3, the client gives informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. Can you follow this?
I already read it once. That's why
B.
I had you read it, because I already read it.
Okay.
And then it didn't record.
Oh, you're recording this?
Yes, I'm recording what you're saying.
Oh, I see a little white button. Okay. A lawyer shall not use information. I sound nasal because I have my glasses on my nose. Relating to representation of a client to the disadvantage of the client unless the client gives informed consent except as permitted or required by these rules. B, a lawyer shall not solicit any substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument giving the lawyer or a person related to the lawyer any substantial gift Man, lawyers are way underpaid. This is insane. Unless the lawyer or the other recipient of the gift is related to the client. Oh, to the client. Okay. For purposes of this paragraph, related persons include a spouse, child, grandchild, parent, grandparent, or other relative or individual with whom the lawyer or the client maintains a close familial relationship.
God forbid they have family.
Yeah, I'm not going to get in trouble anymore, so don't worry about me. Prior to the conclusion of representation of a client, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. E. A lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation, except that there's three. A lawyer may advance court costs and expenses of litigation, the repayment of which may be contingent on the outcome of the matter. 2. A lawyer representing an indigent client may pay court costs and expenses of litigation on behalf of the client. And 3. And then there's sub little numbers. Romanettes. Excellent. A lawyer representing an indigent client pro bono. A lawyer representing an indigent client pro bono through a nonprofit legal services or public interest organization, and a lawyer representing an indigent client pro bono through a law school clinical or pro bono program may provide modest gifts to the client for food, rent, transportation, medicine, and other basic living expenses. The lawyer, Romanet 1, may not promise, assure, or imply the availability of such gifts prior to retention or as an inducement to continue the client-lawyer relationship after retention. Romanet 2, may not seek or accept reimbursement from the client, a relative, or the client, or anyone affiliated with the client. And finally, Romanet 3, may not publicize or advertise a willingness to provide such gifts to prospective clients. Okay, there's more. Financial assistance under this rule may be provided. Careful, your rabbit's coming. Even if the representation is eligible. Let me start this one over. This is hard to read. Financial assistance under this rule may be provided even if the representation is eligible for fees under a fee-shifting statute. A fee-shifting statute. Fee-shifting. F. A lawyer shall not accept compensation for representing a client from one other than the client unless the client gives informed consent, there is no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship, and C, information relating to representation of a client is protected as required by Rule 1.6, if you remember that, 1.6. And G, a lawyer who represents two or more clients shall not participate in making an aggregate settlement of the claims of or against the clients. This is repetitive because they're in conflict. Or in a criminal case, an aggregated agreement as to guilty or nolo contendere pleas, unless unless each client gives informed consent in a writing signed by the client. The lawyer's disclosure shall include the existence and nature of all the claims or pleas involved and of the participation of each person in the settlement. H. A lawyer shall not, there's two things, and then there's a Romanette, make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or two, a lawyer may not settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. There's a little Romanette, and then there's no, that doesn't a Romanette. It's the letter I. I'm sorry. I. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of litigation the lawyer is conducting for a client, except that the lawyer may, 1, acquire a lien authorized by law to secure the lawyer's fee or expenses, and 2, contract with a client for a reasonable contingent fee in a civil case. J. There's J and K. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. K. While lawyers are associated in a firm, a prohibition to the foregoing paragraphs A through I that applies to any one of them shall apply to all of them. Did that make sense? Okay. Let's go on to the next rule. I need to take a breath. Whew.
Are you on 10 yet?
I think this is 1.9. Okay. Let me wipe my glasses. Duties to former clients. So some of this is kind of in my life right now. I'm kind of learning. Okay. Ready? Client-lawyer relationship. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. B. A lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client. And then it has 1, whose interests are materially adverse to that person, and 2, about whom the lawyer had acquired information protected by rules 1.6 and 1.9c. That is material to the matter unless the former client gives informed consent confirmed in writing. C. A lawyer who has formerly represented a client in a matter or whose present or former firm has formerly represented a client in a matter shall not thereafter. 1, there's 2. 1, use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has become generally known, or 2, reveal information relating to the representation except as these rules, in capital R, rules would permit or require with respect to a client. Last one. Rule 1.10. I don't know what this word is, but it says imputation of conflicts of interest. General rule. Client-lawyer relationship. Am I in your way?
No.
Okay, ready? A. While lawyers are associated in a firm, none of them shall knowingly represent a client when any of them practicing alone would be prohibited from doing so by rules 1.7 or 1.9, unless 1. The prohibition is based on a personal interest of the disqualified lawyer and does not represent a significant risk of materially limiting representation of the client by the remaining lawyers in the firm, or 2, the prohibition is based upon Rule 1.9A or B and arises out of the disqualified lawyer association with a prior firm. And, okay, this is a Romanette. There's 3. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. Romanette 2. Written notice is promptly given to any affected former client to enable the former client to ascertain compliance with the provisions of this rule, which shall include a description of the screening procedures employed, semicolon, a statement of the firm's possessive firms and of the screen lawyer's compliance with these rules, a statement that, semicolon, a statement that review may be available before a tribunal, and an agreement by the firm to respond promptly to any written inquiries or objections by the former client about the screening procedures. And the final Romanette 3 is certifications of compliance with these rules and with the screening procedures are provided to the former client by the screened lawyer and by a partner of the firm at reasonable intervals upon the former client's written request and upon termination of the screening procedures.
Is that it?
Do you want me to read that again?
No. Where are you?
I don't know who's being screened. I'm right here.
110 or 19?
This is the last one.
Okay, well here we can turn it off. Perfect. Great job. And yeah.